And with the statute, let's begin with the definition and rules of construction. Rules of construction, in that this is how we construe the intent, which is based on banking laws, of the parties, the venues, and the jurisdiction of this thing called the Fair Credit Reporting Act. If you notice with the complaint itself, the moneymaker that we just showed, a complaint is structured in a very simple and formal manner. First, it shows the basis for jurisdiction, then it shows the basis for venue, and then it shows the party. After that, it goes into the substance as to why you bring in a verified complaint in. The last part is the damages and the prayer for relief, which would also be part of damage, the jurat, the signature, and the certificate of service. Simple. By the beginning, it would always speak about jurisdiction, venue, and party. Those three attributes, if your complaint, regardless of whether it's specific to this or anything else, if your complaints do not have those three attributes, and you just throwing something together and you just explaining what happened and why you should get compensated or why something should happen to the other party, that's not sufficient. What is the jurisdiction? What is the venue? And who are the parties? Then you begin to go into the material factor involved. Then you begin to go into what you deem appropriate as a relief. 15 USC 1681A. Now, for the sake of easy read, we're going to go over the statutized version. But when I did mine, I put into the court docket exhibits of the public law version. Why? Because the public law version shows that you're dealing with the congressional intent itself, rather than the statutized ex post facto. Although when they make reference to it on their end, they will use the statutized version because that's the only angle they can come at from. But nonetheless, the congressional version, which is the Public Act, which the statutized version has its root from, says the exact same thing. But the statutized version here on this website is compiled much easier, and it's easy and straightforward. Definition and rules of construction set forth in this section are applicable for the purpose of this subchapter. What subchapter? Subchapter 3. And everything else under it. Title 15 of USC is dealing with commerce. Anything commerce related. Federal Trade Commission, securities, securities exchange, security investment, public utility holding companies. By the way, when you want to discharge your public utilities, electric, all that stuff, gas, part of the intent of how you can do it is right here in chapter 2C. But we're not going to deviate. It talks about investment companies, omnibus, trademarks. It talks about trading with China, etc., etc. It's all about specific commerce. Part of it is the consumer credit protection. So when people go on about commerce this, commerce that, commerce this, commerce that, Title 15. And part of that is what we're dealing with. We're strictly dealing with commerce. So you see now the importance of the non-UCC before you begin to do this, because in commerce it's all about who has interest. You see why you're coming in through the DBA, which will compel them to act quick and to run to you to say, oh shoot, so you have this much billions of dollars worth of lien or millions of dollars worth of lien on this thing that we're sharing interest in the back end, and then you have interest in it on a county level. Sir, ma'am, please just take this amount and just leave us be, okay? We don't want any smoke. That's why you do those two things, non-UCC and DBA, before you step into this, because you are stepping into the world of commerce, and the language of the statute that they communicate through that shows that they're liable is within the title that governs commercial activity, which is Title 15. Definition and rules of construction set forth in this section are applicable for the purpose of this subchapter. Listen to this. The term person means any individual. Let's pause right there. Just so you know, this entity, Muhammad Lawal, that was a CPN. Remember, you can do this within leagues if you want. But here's a little creative thinking when it comes to commerce. When you create your CPN, see, there's a reason why the CPN was initially introduced. There's a reason why we haven't gone deep into it. I wanted to make this video first so you can really comprehend this, what I'm about to say, before we go into how to create CPN. When you create your CPN, it's very easy and it makes everything easy for you to do your first CPN. Now, you can have your different CPNs in different names, but it's the best to do it in the same name as Enzligas. Why? Because one, you can use the ID for that same CPN that you already have for the Enzligas. For instance, passport or state ID when it comes to certain things. So you're still not limited, but it's still not attached to the social security number. Two, you can easily and easier claim the interest to it. It'll be easier because when you do a DBA, it can cover both Enzligas and the CPN itself. That way you don't have to spend time and extra monies and extra effort and creating different files for different names. When it comes to commerce, you have to think creatively. Two entities or two people can have the same name, but the identification number can be different, which was what makes them distinct entities. Just as much as two men can have the same name but different social security numbers, hence creating two separate files. We'll put that into abeyance until next time when we speak about the CPN. The term persons mean any individual. That complaint that I just showed you was not the Enzligas, because the use of Enzligas was put aside by me long ago. And when I put it aside, I realized, you know what? Let's do something else. Leave that Enzligas be. Once you stop using it, its activity dies out and it ceases to be active, and you take it from there. That truly makes it private, because now when you come through CPN, they are truly coming after your private property, and there's no inkling or hint of them having any interest in it based on the social security insurance which they create. You see, now it's purely property dispute. Now they will be running to you because they can tell the difference in their system, whether it's a CPN or a social security number. And when they see that it's not a social security number, which they have equitable sharecropping interest to, because they are the one who created a social security number as insurance policy for their activity to hold them harmless. And they see that, look, we don't have a social security number attached to this name, yet this man is actually doing business and has a credit file and has a DBA and has a lien on it. Oh, our bad, sorry, here, take it. So the thing about them is they can still monetize any given entity so long as it meets the algorithm of the Oscar, which we'll be going over in the future when it comes to how to create CPN. They're gullible. They can quantitative, easing, and fractional banking, all that can still be done. Remember, the whole purpose of banking is to create money out of thin air, so long as you comprehend the algorithm of how the system itself works. They have fixed lines and bounds they can function in. And if you can come from outside and throw a bait in and just reel it in, you're functioning on commerce. But you can only do that with a proper comprehension of the different compartments of how things work and your ability to unify it by simplicity. We're getting there, a step at a time. The term person means any individual, aka your CPN, which in my case it was exactly what was under dispute. That name, Muhammad Lawal, that was not the social security. And we'll be showing you partnership, corporation, trust, estate. Remember, for those who have gotten the Express Trust, you will see that there's a property list and there's a section where you add your CPN and a social security number as list that the Express Trust owns. And guess what? When you do that non-UCC, the secure party is going to be the trust. It's all adding up. And part of that trust member will be you, the spiritual name. In my case, it was Muhammad Bey, doing business as Muhammad Lawal. See, the trust itself doesn't have to blatantly step in. The trust is the big man in the back looking at everything going on. And you being a party to that trust and that CPN that they've trespassed upon. Or it may be the Nsligas. It can be the Nsligas. But my thing is, just leave the Nsligas be. Leave it alone. Don't tamper with it. It's their stuff. Leave it be. But if they come at it, at least you know you have recourse because you know how asset protection works. But create your own algorithm just like they created that. You have the power and ability to do so. That's the reason why Lady Justice has that sword that's double-edged. Meaning just as they're using that algorithm, so can you. That algorithm is double-sided. Anybody can get it. Which is why it bothers me a little bit when I hear people complain over and over and over. Just stop whining about it. Know how it works and put it to use, because commerce, doing business, is your birthright just as much as information, and your use and your ability to access the information is also your birthright. Birthright is not just some land or some title that some people go on about. Being, quote, sovereign is not about merely being left alone. Okay, you can say you want to be left alone, but the way this world works, there's only a very small 6 degrees of separation between you and I. And that which everyone else does affect you and I one way or the other. So as much as you might want to be left alone, others' activity would at one point blend in with yours. And if you don't know how commerce works, if you don't know the algorithm of how it works and how you have the power to make it work for you, you will merely be a victim. We're not victims here. Again, the term persons means any individual. They're making it clear, any. They're not restricting it because Title 15 is about commerce, and they know commerce is vast. A partnership, corporation, trust, estate, corporative, association, government, or governmental subdivision or agency, or other entity. Do you see what they're telling you here? They're letting you know they're not restricting this term persons to just one type of entity. They give you specific types. Then towards the beginning, they leave an open field, like a blank template, to say, look, it can be any individual or other entity. Now it's incumbent upon you to know the different types of entities that exist and how it can be validly interfaced with them through your ability to protect it. And more importantly, as applied in this case, how you can cause them to run to you with monies. If someone is going to say they're going to create a monetary system to benefit off of it, there are little small, subtle, minute ways it benefits you also. The term consumer means an individual. It means an individual because two people can enter into a contract and report the violation of that contract or the intent to access one's credit to the credit bureaus. So it doesn't necessarily have to be big corporations like bank. It can be a man and a woman that does this. They call it there's an account with Experian and Equifax and TransUnion that anyone can actually buy in order to furnish credit. Yeah, you can furnish credit on behalf of someone else. We'll be going over that in the future too when it comes to extending credit, where your trust can actually extend credit to others through certificate of deposit. And what you do is you establish a credit furnisher account, and you can really actually create your own credit profile and extend yourself credit through different means. But you first have to know how CPNs are created first. This is why I say when you get it, you can layer it as much as you want. And I hesitate to speak about things of that nature in details because many people are just loose and they use information uselessly. They're not prudent with it. They like burning things out. And what that does is it causes those other people, on the other hand, to change up and switch up the game. So there's a hesitation on my part to speak on that. But nonetheless, it tells you about how you become it in the different ways you can. It goes on to say the term consumer means an individual. An individual is a very vague term. It can be anything, natural or otherwise. The term consumer report means any written, oral, or other communication of any information by a consumer reporting agency bearing the consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living which is used or expected to be used or collected in whole or in part for the purpose of serving as a factor in establishing the consumer's eligibility for what? Credit or insurance to be used primarily for personal, family, or household purpose. For what purpose? Employment purpose. For what purpose? Any other purpose authorized by Section 1681B. In other words, in order for any bank or any entity to access your credit, they must prove that it was for credit purpose, for insurance purpose, for employment purpose, or 1681B, which speaks about permissible purpose of consumer reports, which is part of the things that you'll be mentioning within the complaint itself. When you look at this part that says undisputed material fact, it says violation of Fair Credit Reporting Act, and one of the sections is 1681B. They cannot prove that they have permissible purpose, because as we've mentioned, in order for them to prove that they have permissible purpose, they'll have to show the private contract they have in the back end with each other. And what that private contract constitutes is the buying and selling of that entity whose credit report they're accessing. That same entity whose credit report they're accessing by buying and selling its information is the same entity that you have first lien interest on by way of your trust that you have created as an algorithm of yours as first lien holder that no one else has created or insured. Property, right. Contract, right. Trust, right. Private rights, by way of the guidelines of their limits and confine of how they can interface with it. Permissible purpose of consumer report. Remember, they've defined who consumer is for you. It means an individual. They don't specify what an individual is, and they don't specify what a person is, because they cannot. The moment they begin to do that in commerce, that is a red flag that something is wrong, because it would not benefit them also, because this medium of vagueness of what a person and a consumer means is how they make money. Without that, they're not going to be able to easily homogenize people with arrest record, child support, mortgage, bank loan, car loan, all that trash. They cannot do it. In other words, it's a double-edged sword. If you get these principles, you'll be able to repeat it on a higher level and a higher increments with different types of suits. See, this suit is just an introduction. There's more. Nonetheless, permissible purpose of consumer reports. Subject to subsection C, any consumer reporting agency like Equifax, Experian, TransUnion may furnish a consumer report, meaning the private information which shows any written aspect of the credit worthiness, the credit standing, the capacity, character, the address, the first, last name, the age, the date of birth, private biometric data that you own by way of your trust. General reputation, meaning, well, who have you done business with in the past? How do they have a right to know who you've done business with in the past if they're not permitted to do so? Personal characteristics, date of birth, mailing address, which is based on the eOscar algorithm that we'll be going over. Mode of living, is it a resident area? Is it a home? Is it an apartment complex? Which is used or expected to be used or collected in whole or in part for purpose of serving as a factor in establishing consumer credit. Consumer eligibility for credit. insurance, employment, or 1681B right here. It tells you whoever it is that is coming to access that information that has all those details, those people holding that information as the trustee of it, before that other party puts a lien on it as an interest of business, these consumer reporting agencies, Experian, Equifax, and TransUnion, in order for them to release the information, they have to have a reason to believe that whoever is asking for it intends to use the information in connection with a credit transaction involving consumer on whom the information is to be furnished and involving the extension of credit to or review or collection of an account. This applies to debt collectors, student loan, etc., etc. The consumer or intends to use the information for employment purpose or intend to use the information in connection with the underwriting of insurance involving the consumer, or intends to use the information in connection with determining the consumer's eligibility for a license or other benefit granted by a governmental instrumentality required by law to consider an applicant's financial responsibility or status, or intends to use information as a potential investor or servicer or current insurer in connection with evaluation, blah, blah, blah. Meaning you're doing business with them one way or the other, and they need to access what to determine whether they want to do business with you. They need to access your creditworthiness, standing, capacity. See, these words are out here, man. Your standing and capacity. It's through the ownership and interest of the trust. When they see the standing and capacity, this is what compels them to settle quick. If they want to do business with you, they need to access the creditworthiness, standing, capacity, character, general reputation, characteristic, motive, living, etc., etc. And the only way that they're permitted to access these attributes of any given algorithm based on 9-digit first last name, first 3 numbers of your address, and all the criteria of EOSCA is they have to do it for the purpose of insurance, for the purpose of employment, for the purpose of extending credit. Those are the 3 main categories that's listed here in 1681B, which is one of the things you'll be naming as undisputed material fact that they have violated. Once all that's done properly, within about 10 to 15 days of you putting that complaint in, none of the BS that they tried with other people in any other case would occur, because the acting judge will really not give them an opportunity to come in and start running their mouth. The acting judge will get straight to the point because they see exactly what's going on, and because they would always want to assist those other parties, what they'll do is show them instantly that, look, your best bet is to not go on a long-winded battle with this guy, because no matter what door you try to take out, it has been closed as a checkmate before this man even filed the suit, because of all the things we've spoken about when it comes to asset protection and how to properly come in beforehand. See, the hardest part of a suit is the setup itself before you file it. It's like an alley hoop. The moment you file it in, they create a docket number 1:22-CV- whatever. Whenever that clerk issues that receipt that says you filed that complaint, that is that moment where you're in the mid-air, when you got the ball in your hand and you're about to dunk that thing. Everything else is just your moment of stardom where the cameras are flashing and you're looking cool in mid-air. And the spectator is going to say this: the docket entry was made by the clerk on Monday, February 7, 2022. Then an entry before Honorable Telephonic Status Hearing held on 2/7/2022. This is when you file the suit. They get straight to the point. Deadline for completing discovery is 8/8/2022. Deadline for amending the pleading and adding parties is 5/9/2022. Plaintiff is to make settlement demands to the defendants by 2/21/2022. Meaning you filed this during this day. We see it. We don't even want the months to end. Just go ahead and demand monies from them privately and leave it out of the public, because I, as the acting judge, I see what's going on. And I'll be speaking to these attorneys if they don't get it privately, that they don't want this. Because if you don't settle and this becomes a res judicata, everyone else will be putting this to use. They don't want that. But look, if you want to prove a point and you want to turn to a res judicata, you do that. But let me tell you something. If you intend to turn to a res judicata, they will make it hard for you. They will pay the judge off, and you have to go through appeals. And appeals can take anywhere from 2 to 5 years to complete. So there's nothing wrong with it. If you intend to do that, all well. But while you're at it, before you get there, just, make a little bit of residual income here and there. Just every now and then. When that time comes, do that. But make this a way to make a little bit of money here and there, which is the only reason why you and I are talking about this. Defendants are to respond by 3/7/2022, meaning they're saying once this guy makes a settlement demand, not often would you see an acting judge put an order like this, meaning when the case starts, they are already trying to end it. Like, look, just settle with this guy is what they're saying. And I'm telling you, when you come right, this will be the demeanor of the acting judge right off the bat with you. Look, just make a settlement with him, and once he makes a settlement, just settle with him within a month's time. Just settle by 3/7/2022. Telephonics status hearing, meaning I don't want to hear anything else. I'm going to give you a due process to ask for anything, just to give the appearance of us going through the motion of, the proper court and all that stuff. But really, look, just make a settlement. And about 7 days or 8 days after you've accepted that settlement demand from the guy, just let me hear what you've came to. All right? And here's the number, here's the access code. Just get rid of this case so this guy can dismiss it. Besides the fact that the acting judge is going to be giving you a straight demeanor, talking in a casual term, like, look, how is this guy supposed to know what you guys have going on privately? Because, of course, the acting judge also skips straight to information and sees exactly, because, see, all acting judges have law clerks who basically, whenever you file anything, the acting judge themselves don't actually read the papers. Their law clerks read it. And then based on the isolation of what's valid and what's not, the law clerk funnels the important stuff and then hands it to the judge. And part of the stuff the law clerks will be running on that name, trust me, based on phone calls, which we'll be going over, is they'll be looking at how you've protected your asset before coming in, which will make them type this up. The law clerk is the one typing all this, not the acting judge itself. That acting judge is not doing all this job. All the acting judge is going to do is just show up during the day, look at the summary that the law clerk has written, and make a decision based on the summary of the research that the law clerk have done and after reading all the papers. That's the truth and reality of what goes on behind closed doors, in case you guys weren't aware. But this is going to be the other demeanor whenever they bring something called minute entry. And under the note of minute entry, since the docket is just a receipt by the clerk that is showing what's going on, the transaction on the commercial level of the business affairs of the court, this thing called minute entry, just like a trust minute, like you would have a trust minute, this is a trust affairs going on right here. And wherever trust affairs are, there's property interest, because remember, in order for trust to exist, someone has to hold property on behalf of another. Do you know what those trust properties are when it comes to courts and their trust minutes? It's that bank account called the case number. And the thing is, when you come in properly through asset protection, they cannot monetize that case number. All these minutes are about that property that they own, which is the case number, because it's their creation. Now, you're not creating the case number so and so, they are. So that's their property that they're monetizing. Just like a money will have some inscriptions of numbers, a letter, and combination, and that combination of numbers and letter has monetary value in stock market. Same thing applies with cases. And cases like this are bad investment for them, because you're already coming in under something that's yours. On every end, there's always an incentive for them to close it as quick as possible because it doesn't benefit them. But you, though, it benefits you because you know what you're doing and you're coming in properly. So those are the subtleties of what really goes on beyond what meets the eyes when people hark and bark about court is commerce, blah, 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 all that. Okay, we get it. But what's the functionality of it and how you can put it to use? That's what we're speaking of here. This is the demeanor they will have towards you. It's one of those, look, let's get rid of this as quick as possible. It doesn't benefit us. We get it. He knows what he's doing. You don't want to be liable as the defendant. So go ahead and settle with this guy. And look, here's a court order saying just go ahead and do it quickly, okay? We know you've done it before in the past, before coming in, but just go ahead and do it so we can go through the formality of showing due process and all that crap. And look, just accept this guy's offer and close this damn case. That's what's being said here. When you come right, this is what you're going to be seeing every time you file this type of suit. Maybe the first or the second time, it might not be that way if you've never sued anyone or if you've never dismissed a case. You know, things of this nature, the pen and paper. But after about the second or third time of doing this, it will be bread and butter for you. That is when you will truly begin to enjoy the things that come along with knowing certain information. It doesn't hurt to have an extra 4, 5, 10, 3K in your pocket every month or two, and you don't have to go clock in, clock out, and you don't get taxed for it. We'll be showing all that with the Form W-9. This is the reason. I'm telling you, this is the reason why the trust has to precede everything. I will show you the W-9 form that you fill out when they do a settlement agreement. Now, they will not tell you have to fill it out so that they can withhold it, but some of them will tell you. But after trial and error, you learn it. But you don't have to go through the trial and error that I did. It's being given to you, so you do it right off the bat. And when you do it, those attorneys on the other end will know, oh, you know what you're doing. All right. Okay. Because now they will want to screw you over through contract in every way, because that settlement agreement is another contract. And if you don't enter into that contract properly, they will screw you over, tax you, trigger a taxable event, report you to the IRS that, hey, look, this guy just made some money through some court case. Go get him. We've withheld this amount. Now that's a whole nother headache. Why put yourself through that whole nother headache when in truth you're doing this to bring the heat to them, to alleviate the heat from you? Remember, subrogation is the name of the game, and they're very good at it. If one doesn't know how asset and property, right, and trust and contract work, every corner you turn will always be subrogation waiting to slap you. This is the reason why we're doing this video, so we can show it a step at a time and explain the little small things involved so that your eyes can be open to what's really going on. Now let's reverse just a little bit. On the patron page, on the 6th of May, a post regarding this exact 15 USC. Section 681. It was posted as a text on the Patreon that the intent of 15 USC 1681, according to Congress, the congressional intent, is all based on banking. If you comprehend the congressional intent and purpose, which they call congressional finding and statement of purpose, of this thing, 15 U.S.C. 1681, which Fair Credit Reporting Act is embedded into, you will see that it's all about commerce, and you will see the reason why trust and asset protection is the core of why this works. Anyone can do this, but if they don't use trust and asset protection, it will drag on and they will milk this case even if they know that you're correct, because you're not coming in right. 15 U.S.C. 1681, congressional finding and statement of purpose. Then why did we create this thing within 15 U.S.C.? Accuracy and fairness of credit reporting. The Congress makes the following finding. 1. The banking system is dependent upon fair and accurate credit reporting. Inaccurate credit reporting directly impair the efficiency of the banking system, and unfair credit reporting methods undermine the public confidence which is essential to the continued functioning of the banking system. Meaning when you come right with the asset protection and you prove that something was accessed within something that you have first lien interest in, it can undermine and impair their banking system because you have a lien against that thing that they've unlawfully accessed, and they will never show the private contract between one another, as was shown in the court order of the judge saying, look, how is he supposed to know if you're not going to show him? Because they know they're not going to show it. Because if they show it, now those non-UCC and trust rights truly obviously kicks in, and they will never want to get to that point, because you will begin to screw up their system by impairing it and undermining their banking system. And if you turn into a res judicata, it will change the public confidence in their system, and they will never want to get there. An elaborate mechanism has been developed for investigating and evaluating the credit worthiness, credit standing, credit capacity, character, and general reputation of consumers, just as we've read in those other previous sections. Same exact concepts, same exact words, same exact intent. You see the fine line that they function in? Consumer reporting, which we went over who and what consumer is. Consumer reporting agencies, which was also went over who consumer reporting agencies are. And we've listed them on Patreon also, depending on the type of contract that you entered into. Consumer reporting agencies have assumed a vital role in assembling, meaning they are trustees of mutual parties of collecting information, and evaluating, meaning they have a responsibility of handling it in a certain way. Consumer credit and other information on consumers. There is a need to ensure. When you see this word insure, it's all commerce and money. Insure, aka the social security number insurance against illegas. So when you come in through your own creation of algorithm, the one who is insuring it is not them. The one who has the first lien hold interest is not them. The one who is insured, like when you get a car insurance to insure whoever is driving against damages, the one who is insured is not them. It is you, because you know how trust law, contract law works, because you've taken certain steps before even coming in this way. And what does that make them? It makes them the one liable to compensate you. So they will run to you to settle, and the acting judge will see it clearly, because when you fill out the cover sheet on the federal level, when you fill it out correctly, the proper and correct judge will be assigned that knows about things of this nature. So they will be able to see the fine line between what you're doing and be able to see that, oh crap, look, go settle with this guy. And they will release that minute order based on their trust of that case number, account number, which they monetize, to say, look, we cannot insure you against this crap. So this guy is going to come to you and give you a settlement offer and accept it within 15 days, 2 weeks, and come back and give me a report on it. Are you seeing the fine line between everything that's going on? To layman's eyes, they will read this and casually go over it without comprehending the totality of circumstances and the subtle intricacies involved in everything. There is a need to ensure that consumer reporting agencies exercise their grave responsibilities with fairness, impartiality, and a respect for consumers' right to privacy. This ensure doesn't mean we're making sure. To ensure, E-N-S-U-R-E, is a completely different reality from to insure, I-N-S-U-R-E. Insure deals with monetary interest of preventing liability by way of insurance. Ensure meaning we are ascertaining, we're making sure, we're doing our due diligence, we're double checking, we're dotting the I and crossing the T to make sure that this happens. To ensure meaning, look, there's a chance that if something happens, in this case with privacy and information, when it comes to evaluating, handling, assembling, collecting these people's information, we have to insure ourselves. Through what? Through the Social Security insurance, based on the algorithm of the Oscar. But you have to come in with yours that's not sharecropped with theirs, so they cannot be insured against it. And they would only have one way out. because you've checkmated them before you even begin, and that is to simply settle. And the acting judge will concur with that and release orders with tones that benefit you, because they know you are different and you know how commerce works. You're not just babbling on and on about this happens, that happens, this PDF, that PDF, the IMF, the IRS, the quarters, the commerce. No. All that is child's play. All that is introductory accumulation of information. Now let's put all that information to use by functioning with it. And while you're at it, make a couple of residual income here and there and kick their butts. That's what's going on. That is what all this is telling you. Again, one can read this legalese and read it one way, but the truth is exactly what we've just expressed. That is the reality behind what is going on the forefront and on the back end. Reasonable procedures. It is the purpose of this subchapter to require the consumer reporting agency, required meaning it is their obligation. They are required. The burden of proof right off the bat is on them when it comes to your privacy. But you're not deemed to be private if you're coming in regularly as the legas, if you're not involved in trust and asset protection, if you're not involved in things like UCC and DBAs, which you'll be coming in through. Reasonable procedures. It is the purpose of this subchapter to require the consumer reporting agencies adopt reasonable procedures for meeting the need of commerce for consumer credit, personnel, insurance, and other information in a manner which is fair and equitable. When you come in through a trust, you are automatically invoking equity without using that buzzword equity. When you do a non-UCC first before you come in, you are the first lien holder. And equity does what you ought to, meaning it's your stuff and you're coming up now for restitution. Who's touching my shit? Give me my shit back or else compensate me. On YouTube, we went over usufruct. That's basically, if it's something that's depletable, whether corporeal or incorporeal, well, make me a whole again. If you've used it by accessing it, give me my money. You owe me. And you're required to. Because you're not insured against it. And the thing about insurance is, insurance names the one who can cash out against it. Insurance names the parties to it. The insurance company is the trustee. The beneficiary is the one making a claim to it that you've damaged one way or the other. The one protected is the one that's insured, but they're not insured against it. Since you're not coming in through that legas, you're coming in through your own created algorithm. You're the god of that reality, of that algorithm that you've created based on your understanding of how the system itself works, based on how the quote matrix itself works. On this level, there's more. But there's no way we can talk about more if one doesn't know and comprehend this basic stuff. But nonetheless, ensuring the other information in a manner which is fair and equitable to the consumer with regards to the confidentiality, accuracy, relevancy, and proper utilization, usufruct, to use, utilization of such information in accordance with the requirements of this subchapter. That is the intent of Congress for creating this thing that you are going to be coming in and smacking them with. And you're asking, well, what if I have child support? And you have that child support attached to your credit, even if it stands legas, don't worry. This is applicable too. They've been garnishing your monies years after years after years. Remember, this not just only applies to any given credit card or student loan. This applies to mortgage, child support, etc., etc. So you have child support, right? The same 15 U.S.C. 1681B that speaks about permissible purpose for consumer purpose tells you a little bit of something about child support also. In response to a request by the head of a state who is responding to the Consumer Reporting Agency, meaning the only personnel that could come when it comes to child support to access your credit when it comes to child support related stuff is the head of the state or local child support enforcement agency. They will come to the consumer reporting agency, and the consumer reporting agencies in response to such requests according to permissible purpose of how they can access it. In response to a request by the head of the state or local child support enforcement agencies or state or local government official authorized by the head of such agency, meaning their contractors, their buddies, if the person making the request, meaning the child support related agency, making a request to the consumer reporting agency, Equifax, Experian, so and so, if the person making a request certifies to the consumer reporting agency that, meaning there has to be this document that is a certification which they have to prove as evidence of permission. They will never have the certified document. They will never have it, because that certification is going to be going along with everything else of how they monetize and basically use you as a slave. They don't want that out. They want to keep that vague and speculative. If the person making a request certifies to the consumer reporting agency that the consumer report is needed for the purpose, remember this is specific to child support now, for the purpose of establishing an individual's capacity to make child support payments, determining the appropriate level of such payments, or enforcing a child support order, award, agreement, or judgment. The parentage of the consumer for the child to which the obligation relates has been established or acknowledged by the consumer in accordance with state laws under which the obligation arises if required by those laws. And, meaning these are the three requirements. They have to certify that the only purpose that they are accessing your credit report or that credit report when it comes to child support is to determine the appropriate level of such payment, the enforceability of the order, court order, the enforceability of any awards or private contract, or to see if the obligation itself relates to the consumer according to state law. And the consumer report will be kept confidential, will be used solely, meaning strictly, for the purpose described in subparagraph A. Subparagraph A, this. And will not be used in connection with any other civil, administrative, or criminal proceeding or for any other purpose. When it comes to child support, this is a specific algorithm you use in place of employment, in place of insurance, in place of other criteria mentioned here. Now here's the important part that also applies to the intricacies of how this works. If you physically filled out any given application for any given purpose, meaning you apply for credit, one way or the other, and you know you did it, if it's done online, that is the best way to really bring this claim. We've explained the reason why compared to a written verdict, because they will be quick to whip out that written contract, and they will be quick to whip out that camera if you're stepping in there signing that contract. So use the brain a little bit on this one. Don't be gullible.